Hey, Kelly, we had a question asked in the queue about assignment. And the question goes like this. Why would hotels need a one-sided assignment clause in their group sales contracts?
And I'm so glad someone asked that because it rarely ever gets raised until they try to make it mutual and I have to reject their changes. So the reason for a one-sided assignment is as follows. So hotels make various decisions about groups based on their financial wherewithal, based on the type of group they are, if they have a history with them. They also base it on, especially if there's a competitor clause, who their competitors are, that type of thing. The reason we can't have a mutual assignment clause is because you can't assign, or the ability to assign, I should say, a group cannot assign for those various reasons. We cannot, as a hotel, allow someone else to assume your contract unless we've agreed to it, because we haven't vetted their financials. We don't know who they are in many cases. And more importantly, that group could create another conflict with another contract because of the fact that they are coming into the hotel when there's folks in the hotel who identify them as a competitor. And so that's why we can't have one side. We have to have only one-sided assignment clauses. More importantly, from an owner's perspective, owners frequently might flip a hotel or they might move a hotel to a affiliate or subsidiary of their under their umbrella, and we have to be able to do that across the board. In those instances, the group is likely never going to know or even see a situation where the ownership has changed either technically or otherwise, because of the fact everybody in the hotel is still employed there and all the people are still the same. There might be instances where a hotel will agree to notify a group if there has been a sale in case of that creating any kind of issues on the group side. But as far as a prohibition or having to get permission from the group to assign the hotel contract by the hotel, that's just never going to happen. What is your experience been?
Well, I appreciate the explanation, Kelly. And I think, a lot of groups are accustomed to any assignment clause. And just as you described, assignment means you're giving someone else your rights under the contract and your duties or your obligations. So that's kind of the legal meaning of that word. And, I think groups become accustomed to just the standard rule, right? Neither of us can assign without the other's consent. The hotel context and the way you described, I think, is very helpful. I will say I've had a lot of group clients over the years where they did need to assign, in some cases because of an acquisition. And oftentimes that might be easier to, in other cases, because they may be partnering or affiliating with another group. And my experience has been that in that way, we the new group proves its financials and the hotel vets all the things you mentioned. And ultimately, we were able to get the hotel's agreement on an assignment. That's, we sign off on that, of course, in writing. So there's definitely a formality to it, and that formality is important. And on the group side, if you anticipate the need to assign, address that up front as an issue, because there are ways that you can negotiate that into the contract if needed. And again, I think being upfront about it, being transparent about it is a good strategy. But that provision, I agree with you, Kelly, it doesn't get a lot of attention often. And yet, when
Right.
we hear it come up, I'll hear a group say, well, we were bought by another, but the contract's in the other name, but that's okay. And I'm like, yeah, we want to have some formality there, right? I don't want you to show up and like, who are you?
Absolutely.
So yeah, so that leads, Kelly, I think, to that second point about the potential that a hotel might cancel on the group. And I know we had a question about that.
Absolutely. So the question that was raised that we didn't reach earlier, but I'd love answered is, what contract language or formula do you suggest to protect planners from hotel cancellations? Hotels have a way to calculate their loss, but planners don't.
It's a great question, and it definitely illustrates the point and the challenge that groups have. And that is, in as much as a cancellation fee, if the group cancels on the hotel, can be built on the potential of lost revenue for rooms and food and beverage, and is also built on a sliding scale, closer in, higher the fee, farther out, lower the fee. That makes sense. But in the same way, cancellation by hotel, if the group has to look for a new hotel, we never know at any given point in time what hotels will be available. where they'll be located, if they could still be in the city, what the rates will be, et cetera. So the challenge when, for example, some chains want to have a mutual cancellation fee and they want to base it on group, damages group would pay if they canceled. When a client says, why are those reasonable? We have no way of knowing. And yet you may be agreeing to cap your damages on that. And so that's an eyes wide open. Group needs to be aware of it. In other cases, the hotels will agree that they would be responsible for group damages, but they might cap them to the max, right, on the cancellation fee schedule. So we're kind of back at the same position. Or my preference would be to just say you'll be responsible for these types of damages that without a cap. That would be an ideal. One cap I'm seeing nowadays is a cap, not on the cancellation fee schedule, but a cap on what the group would pay the hotel. And what's interesting about that in an overflow contract, you might have a minimal rooms on a master account. And so this is a nonprofit event, right? And so what that group's going to pay that hotel is pretty little, and yet they're agreeing to cap damages on that amount. So what do I think is reasonable? I think you have a grocery list, if you will, of damages. Specifically, Kelly, I know we talk a lot about types of damages, but I would say direct damages are really what you want first and foremost. Those are the outflow. Those are all the but-for costs. Had the hotel not canceled, I wouldn't have to look at this hotel and pay these rates and so forth. And then look at any other costs that might be associated and potentially adding in attorney's fees. So I think having a grocery list is a good strategy. I think also it's good, you could say this group's reasonable costs, fine. You want to say documented costs, no problem. Well, reasonable, documented, maybe you want to limit just to direct damages, indirect or consequential damages. That's that second level fallout. An example I use for a lot of associations is if you had to move your meeting, the costs of moving it are direct, but if as a result of moving the meeting, you lose the presenting sponsor, that's an example of an indirect. And so unless you specifically call for a contract, you're not going to be entitled to it. So what I would just encourage groups is just to have a placeholder. And Kelly, as we've been talking throughout the webinar today about issue focused, what I would say to a group to a hotel on this issue, I would simply say, we just want to have something to point to if the hotel were to cancel on us. Because yes, we know we might have our own remedies for breach of contract and we don't have to put something in the contract. But my point would be having something in the contract allows us to, as a starting point, allows a process for it. And I think that to me is as important rather than saying you got to go to arbitration or litigation and all that. So those would be my recommendations. Kelly, I know you deal with this issue a lot on the sides of hotels that often don't want to cancel on group, but sometimes
Right.
circumstances arise.
It is certainly not a goal or even nor does it happen very much, but it does happen on occasion. One thing I will add to the discussion is that it does need to be negotiated if there's going to be any type of clause. But what doesn't work, and I have seen it a lot lately, is someone trying to make the hotel's cancellation clause mutual. And it's just, I struggle with it even being enforceable because it's an apples to oranges analysis. Even the question implies that. And so consequently, I don't think that is a way to go, although some people have tried it of late. And the other thing I will say is it's important for groups to understand that if that happens, if there is a hotel cancellation, groups have to mitigate. They cannot wait. They have to find an equivalent property, not a luxury resort or something of that nature to replace something that was a convention hotel. And their obligation in any scenario when that happens is to try to mitigate their losses and then ultimately what the situation is going to be at the end of the day. But it was a great question. I'm glad we got a chance to answer it now. I think it was,
Absolutely. And I'll
yeah.
just add, add to that, Kelly, you make a great point. I completely agree on the mutual cancellation fee. To the point you made about the potential as to whether it's enforceable, just to remind the listeners, a cancellation fee clause is a liquidated damage clause, which is just simply a fancy word for saying the parties agree on damages when it's hard to articulate them. And so again, we have that sliding scale we talk about based on room revenue and so forth. So when you flip it and you say it's mutual, you have to answer the question, are those cancellation fees a reasonable estimate? And I can't answer that question. You can't answer that question. And so that might in and of itself fail, on that first requirement. And then the groups that might try to separate cancellation fee schedule or a set amount that might be higher. The second part is, about a liquidated damage. It can't be a penalty. Exactly. And by the way, folks, don't call it a penalty. Don't call it a penalty, right? Just so a fee. And so, yes, it could give the other party more than it would have received had it performed the contract. And so that's the other way we look at it. So I think that's a good reminder for folks in the confines of cancellation by hotel as well. And Kelly, one other topic that comes up a lot, we had a lot of questions come up. We had some questions in the chat come up during the webinar and also coming in, our friend, the force majeure provision. And specifically using as a standard of impact or maybe a trigger, however folks want to understand that, terms like impractical, C-A-L, ending in C-A-L, or terms like commercially impracticable, C-A-B-L, and of course illegal, impossible. But Kelly, those terms have certain meanings at ART. In particular, what's been your experience on the commercially impracticable, C-A-B-L-E, as it relates to the force majeure clause?
Whoever thought we would be spelling on our presentation, but no, it's absolutely critical to understand. Obviously, there's a difference. I see groups. Obviously, it's not a hotel standard piece of language, but I do see groups trying to add just the word impractical, which I see similar to inadvisable, which in my world, I'm going to use some very unlegal language here, is too wishy-washy. So commercially impracticable has, I'm going to say, a legal meaning, and I'm going to basically be very specific. It arises when the performance of a contract has become unfeasibly difficult or costly to perform. And the difference between impracticability is that it's still physically possible, but there's such a hardship, a substantial hardship for the performing party. And so that's why if a hotel will agree, in whatever instance it's presented, to include language other than the standard second prong, illegal or impossible, we see the commercially impracticable language being more palatable than anything else. Certainly not inadvisable, certainly not impractical, certainly not material impact, or those laundry list of other things that are sometimes presented. And what's your experience been with hotels accepting that?
Very, very good, because they listen to you. They listen to others out there on that term, commercially impracticable. I want to give a quick example of that from the group's perspective, and then also share one other thought on strategy. The example I have on the commercially impracticable, and thank you for sharing that definition, might be that the group is holding a meeting at which there is purely a course for folks to get a certification. And for whatever circumstance, again, beyond the party's control, none of the instructors of the course can be present for that event. That becomes a bit of a increasingly difficult, right? I think we talk about difficult, not necessarily the costly part, but the difficult part. And in some ways, groups might think of that as a frustration and purpose. Different concept, but to your point about unreasonably difficult, right? I think is a good argument there, but groups should focus on that concept of unreasonably difficult. I agree. I like the term commercially impracticable. We're able to articulate, make our case. My suggestion group-wise for strategy, in addition to setting the bar at illegal, impossible, commercially impracticable, we might want to define commercially impracticable, if you will, or if a hotel is not comfortable using it, as a percentage of attendees who can't come to the meeting. Now, there's a lot of different ways that can be phrased.
Sure.
But using a percentage does give what but some would say take it out of subjective and make it objective. Put the burden of proof on the group to establish that. And I would say certainly it's a business term, and I've definitely negotiated those. But a couple points. One, just because in the first prong they have the grocery list and there's an item about a percentage of folks, it may be in the context of an air travel disruption that it's a percentage. In other words, it's a grocery list factor. It's not a standard of impact. So just be careful in sorting that out. And then on that standard of impact, if we say, for example, 30% of the attendees are unable to participate in the event in person, how do we establish that, right? And again, there's all those words in there are prevented, right? You've got to be very careful on how you set that up. But Kelly, I found whether alongside commercially impracticable or in lieu of commercially impracticable, using a percentage approach can get the parties to the proverbial yes faster. But again, I think it's really important that it gets written up in that way, because of course you and I see these on the other side of them when there's a dispute.
Absolutely. Absolutely. Well, I thank you. And I think we've covered the things that were uncovered during the presentation that we didn't have time to reach. And so I'm glad we had the opportunity to finish this, the rest of those concepts for the attendees. And this has been on to our next one, right?
Absolutely. Thanks so much, Kelly. Enjoy always us collaborating you. Thanks to our friends at HopSkip. See you next time.
Bye.